Good morning, ladies and gentlemen. My name is André Klip, and it's a great pleasure for me to welcome you to the webinar on admissibility of criminal evidence in the digital age. We have three distinguished speakers for you. You will see all three of them in the following order. First, we will have Lorena Bachmeier-Winter, professor of the University Complutense in Madrid. Then we will listen to Peter Tsonka, Head of General Criminal Law in the DG Justice at the European Commission. And last but not least, Jorge Espina Ramos, Assistant to the National Member for Spain at Eurojust. Three distinguished speakers that represent academia, practice, and legislation. And on a topic that is of high importance, high currency, as it deals with the admissibility of evidence, and not only of evidence in general, but in particular, e-evidence. We're very much looking forward to the speakers. Just one final remark before I give the floor to Professor Bachmeier. ELI, the European Law Institute, its council has just approved a proposal for an ELI project on admissibility of e-evidence in criminal proceedings. And it's a great honor to give the floor now to the leader of that project, Professor Lorena Bachmeier-Winter. Please.
So thank you very much for your kind words, Andre. Thank you, Eli, for inviting. It's a pleasure for me to share this short 8 minutes with you. And I will try to stick to the time. And my presentation will be, of course, I'm not dealing with all the problems related to admissibility of evidence or electronic evidence, but I will try to make my point, which is why it is so much needed that at the European Union level, there is regulation or at least some guidance in admissibility, mutual admissibility of evidence. So I had prepared a PowerPoint, but the host has to allow me to share it. So if not, I'm continuing with my slides. May I add? Okay, now I can add the PowerPoint. Can you see it? Now you can see it all? Thank you. So you all know that in admissibility of evidence, there are a lot of different criteria, divergent criteria at the national and the cross-border level. So there are countries that really admit evidence obtained abroad just on a principle of non-inquiry, just looking to another side, closing their eyes, do not want to know how it was obtained, but they use it and admit it quite on the basis of absolute trust or complete blindness. And while other countries really do an exhaustive check in compliance with both lex loci, how it was obtained and if it complies, the rules on the obtaining requested country, and also in addition to the lex fori, where the trial is taking place. So we have that divergent approach, which creates a real dilemma also with regard to deciding on jurisdiction. This, at the national level, there different diverse models is also very, very variegated, because there are some countries, and there is a very good comparative law approach by Steve Thaman, who really points out that there are many countries that apply a very strict exclusionary rule of evidence, like in Spain, with absolute nullity for illegally obtained evidence, to a broad balancing test. So any kind of evidence may be admitted as long as it is necessary for the prosecution of serious crime. And then we have at the European Court of Human Rights. We could say it's not necessary to adopt further rules on mutual admissibility on the European level, because there's already guidance at the European Court of Human Rights. But that assessment and that statement is not true, The principle that European Court of Human Rights has followed is that the admissibility and the rules on admissibility of evidence is an issue for domestic courts to decide and for national legal orders to determine. So the only rules is infringement of Article 3 will lead to absolutely exclude the evidence, and other unlawful elements do not render per se the proceedings unlawful. The two main rules on admissibility of evidence is that cross-examination is ensured, regardless during trial or pre-trial, and if it was pre-trial evidence obtained, so the sole and decisive rule of evidence apply. So if we now focus on the possibilities the Treaty of the Functioning of the European Union allows, in Article 82, as we commented recently, to the extent necessary, two aims: facilitate the mutual recognition and the cooperation in criminal matters. The legislative procedure can, and the European Union can adopt laws or directives or a regulation on mutual admissibility of evidence. If you look at the other subparagraphs of 82.2, all the other subparagraphs have been already implemented. Rights of individuals, rights of victims of crime, and other specific aspects like the presumption of innocence, except point A. Why is this? This is not a new question. We have been witnessing a long attempt to introduce mutual evidence and mutual admissibility of evidence at the European level since the Council of Tampere in October 1999. But it seems there is a huge distrust in order not to create a patchwork within the national orders. So every national order wants and seeks to keep their own balancing of their exclusionary rules of evidence, and not accepting very clearly the general rule that as long as lex loci is complied, the admissibility of evidence should be granted. While we see that in the gathering of evidence, there has been a lot of instruments to ensure and to facilitate the transnational collection of evidence. I've put here on the slide the main documents, so the Directive of 2014 on the European Investigation Order, and the Conventions on Mutual Assistance in Criminal Matters of 2000, both, okay, Council of Europe and European Union, and the proposal on the production and preservation order. There hasn't been hardly any advance and progress in the admissibility of evidence. We only find two rules. In the regulation on the European Public Prosecutor, which is a very short rule, just saying and stating that evidence presented, cross-border evidence presented by the European Public Prosecutor or the defendant shall not be denied on the mere ground that it was gathered abroad, which is a very, very general rule on promoting or supporting the admissibility of cross-border evidence, but with no further development. And we find also a very short rule on admissibility of evidence in the European Investigation Order Directive, precisely Article 31, and it states, where necessary, with regard to interception of telecommunications without the assistance of the executing country, any material already intercepted, I repeat, without the assistance of the intercepted country, so to say, the country where the interception took place without its assistance can really forbid the admissibility of such evidence. So it can decide not to use such evidence. So it would be a negative rule on admissibility of evidence, excluding or giving the possibility of the executing country or the country where the measure was executed to exclude such evidence. No other rules exist there. My question is this enough? Should there be minimum rules on mutual admissibility of evidence adopted at the European Union level, at the supranational level? Should there be more action if mutual admissibility is not the path to go? More harmonization towards ensuring that admissibility or exclusion of evidence. I put two examples. I have three here, but I will shorten it. two examples why electronic evidence is now has made the digitalization fostered and accelerated incredibly in a terrific way since COVID, but already existing the need before, that electronic evidence is not just another type of evidence, but it really makes it absolutely necessary to adopt supranational rules. Why? Because electronic evidence is per se and per definition in almost all cases a cross-border evidence. So I put here the example on automated cars, where that will be introduced slowly, but in the next decades. And UK already stated that next year they are already making that reality. What happens if a car is located in another member state, travels around Europe, causing damages or criminal acts in different locations? We have to decide, where is the evidence located? Could the interception of the data that are carried within the car, the robot car, obtained without assistance? Could the car where could the country where the car is located refuse to provide or give access to such evidence because the car is located there, even the server is outside that country? Should only assistance of the state where the data are stored be requested? So these are really, it might sound future questions, but the reality is that we are facing these challenges in a very short time in the future. And we find that in the conventions on mutual legal assistance, there is no answer for this. Regardless how we access to those data, would they be admissible in any jurisdiction? Or could any jurisdiction state, well, these data were not obtained with our assistance, so we refuse to make them admissible? A second example, and I'm running ahead because I think I'm already done with my 8 minutes. What happens with the cars that are backed in operations of controlled delivery of drugs? And these cars cross the borders within Europe, which is very easy because, you know, European continent is quite small, and countries are also quite small, and Schengen area allows to cross the borders very easily. So the geolocation data coming from another country out from the back car, can they use as evidence? There would be a need to notify, but can the other country really block that? And I skipped the last one, which deals with the need for introducing some common criteria on the search of computers in order to comply with the proportionality principle and to protect the immunities. So the point is, we need admissibility rules, we need guidance, uniformity of admissibility rules at the European Union level, but at the same time, not only for the prosecution, but precisely to protect also the level of safeguards to the defendants. So admissibility rules in minimum rules on exclusionary rules of evidence, in order so that the cross-border evidence does not mean a lowering of the standards for the protection of procedural rights. So my final point in the conclusion is that the mutual admissibility has been seen as a measure in order to overcome the diverse legal orders regarding to admissibility of evidence, and the rule that was long ago applied at the international level, which is admissibility of the evidence obtained abroad, as long as lex loci is respected, does not seem to be enough in a European Union area of freedom of security and justice, as the European Investigation Order has shown. And second, ensuring the lex forum, so that the cross-border evidence is obtained following the indications of the requesting country, is not enough either, because there is already a lot of evidence that already exists. So, and data have been already collected, so the Lex Forum cannot be at that stage complied with. So there is really a need to ensure admissibility with a set of minimum rules, and as well as to expel evidence that does not comply with certain standards, to make it possible that we create a real area of freedom, security, and justice. So that was my point in these 8 minutes. there should be a movement towards a legislative draft for the European Commission, at least setting up certain principles as safeguards and to facilitate cooperation. So thank you very much for listening to me. I know it was a very bit of a hassle, but I hope it was made understandable for all of you. Thank you very much, Andre, for the time.
Thank you so much, Lorena, for highlighting the need for regulations on the admissibility of evidence. Thank you very much. Ladies and gentlemen, you have, as a participant, you have the possibility to raise questions, and you can do that via the Q&A box. So if you look at the bottom of your screen, you will find in the middle a Q&A box, and I see that one of the participants already found that. So don't hesitate to put any questions to any or all of the speakers, and at the end of the last, after the last contribution, I will give the floor to address some of those questions. Without further ado, I pass on the floor to Peter Tonka, representative of the European Commission. In her final slides, Lorena already called upon the European Commission, so I think that is a nice news for you, Peter. Peter, you have the floor. Welcome.
Thank you very much, Andre. I hope you can hear me. I cannot hear you.
We can hear you, Peter, but we cannot see you.
Whereas I have pressed the button video. That's a bit strange. I'll try one more time. But you don't lose much if you don't see me. Can you see me now?
We can see you and we can hear you, Peter.
Wonderful. Das ist wunderbar. Thank you, Andre, for the introduction. And thank you for the explanations about the need for action by the European Commission, for the very nice speech that Lorena, Professor Bachmeier just made to all of us. I'm afraid we will not respond immediately to your call. Let me explain why in a few minutes. First of all, this is really a nice opportunity for us to listen to a high-level discussion on admissibility of evidence, including of e-evidence. Obviously, this is of great interest to us. And it's good to hear that the ELI will launch a study and perhaps will contribute even a draft text which will inspire us as it has in the past. So we welcome this and we're grateful to the ELI for having selected this topic for discussion. As I said, I'm very grateful to Andre and Lorena for introducing the topic. This is indeed a topic which we have been discussing for a long time. Many years ago, the Commission adopted a communication that was in 2009. I was in charge of procedural law at the time in the Commission, and we consulted with experts, including practitioners and member states, and they were really divided. So the conclusion of this 2009 communication was that there is no evidence that we have a problem with admissibility of evidence. And there were some sporadic information from some practitioners that in some cases indeed, the locus forum regit actum principles do not regulate sufficiently the admissibility of evidence, and that there have been problems in mutual legal assistance. But this was the minority opinion. So there was no majority calling for minimum standards on admissibility of evidence. And it was even clear that some member states would outright object to it. Politically, they were against it because they considered that this would not fly under the principle of subsidiarity and proportionality. Some considered that an intervention at European level on admissibility would upset their entire system of procedural law, founded on principles such as the free evidence or a numerus clausus for certain types of evidence, and that intervention at European level by legislation would make it unbalanced for domestic affairs. So we had very clear messages from member states that they are not interested in the European Union introducing legislation. Now, of course, the situation has changed a little bit with the treaty. As Lorena reminded us, Article 82, paragraph 2 provides a clear legal basis for minimum standards by way of a directive in order to facilitate mutual recognition instruments. So the Commission could introduce a proposal for a directive in this area. This proposal, of course, should meet not only the requirements of that Article 82, paragraph 2, but also of the protocols to the treaty, in particular on subsidiarity and proportionality. And as you know, we have a strict mechanism of controlling those fundamental principles via EU law. National member states, particularly national parliaments, can object to proposals of the Commission. And we had this situation at least once recently with regard to the EPPO regulation, where a dozen of national parliaments objected to the proposal as breaching the principle of subsidiarity. We thought that it was more about proportionality, but never mind. So we think that if we make a proposal, we will probably face again such challenges from some member states and their national parliaments. But the reason why the situation has changed to some extent and why we will do a study now ourselves is because we have realized ourselves that there is evidence in practice that it doesn't always work. So the two traditional principles of international cooperation, locus in 1959 and forum regit actum in 2000, MLA, are not sufficient, and evidence is not always admitted in courts in cross-border cases. And we tried our hand with the EPPO regulation. The Commission proposal contained two fundamental principles. One is that evidence collected by EPPO prosecutors should be automatically admissible if such evidence meets certain minimum standards, such as compliance with the ECHR and the Charter of Fundamental Rights. And this is so established by the Court of Trial. And number two, we proposed that certain types of evidence be collected by investigation methods under certain principles as well, such as judicial control, a minimum threshold of penalty, so a seriousness of the offense, and the principle of proportionality in applying those intrusive measures of investigation. Now, no need to say those have been thrown out by the member states when they adopted the EPPO regulation. We ended up indeed with the principle that Lorena mentioned, that evidence cannot be thrown out by the trial court only for the reason that it's a foreign evidence, but it can be thrown out for any other reason. So I'm not sure it really solves the problem of the evidence being admissible. Although we have some recitals in the EPPO regulation which could be interpreted generously by the Court of Justice in favor of admissibility, if that happens, we think that the situation will need to be addressed perhaps later on under the EPP regulation, but at this stage we could not do more than what is currently in the regulation. So the e-evidence package doesn't bring us any further either. There is no admissibility rule except when there is a breach of the immunity principle in Article 18 of the Commission proposal. We'll see whether this is maintained by the legislator in the trilogues, which haven't started yet. But this will certainly not bring much progress on admissibility. As you know, we had also a tentative attempt in the procedural rights package, particularly in the directive on presumption of innocence, where we proposed that if there is a breach of fundamental rights, such as the presumption of innocence is not respected, the evidence should not be admissible. This was thrown out as well by the Council in the negotiations. So all in all, there is not much progress indeed since 2009. What is it that we could do under Article 82? And Lorena posed the right question. Is it minimum standards that we could adopt for admissibility, such as a rule of inclusion? You must admit the evidence collected by a foreign judicial authority pursuant to a mutual recognition instrument, provided that the following safeguards are respected, such as there is a minimum level of suspicion, there was a judicial authorization by a proper judicial authority, and there is a minimum level of penalty, such as 4 or 5 years of imprisonment. So it would be applicable at least for certain types of offenses. And we also have some pressure coming from the defense lawyer community, ECBA and CCBE, that we introduce standards for the defense, so that defense lawyers can challenge evidence collected in such cross-border cases. So under this set of circumstances, we decided to launch a study. The terms of reference have been published recently. This will be a study that we hope will attract academia, interest from people such as those sitting on this panel. And we are interested in the views of practitioners, policymakers, and of course, European organizations, agencies, bodies such as Eurojust, Europol, those running joint investigation teams, and seeing problems with mutual recognition or all type mutual assistance instruments. On the basis of that evidence collected, since we need evidence before we get on with the impact assessment, we will consider the options that we have. I'm not sure what the options will be, but our options are indeed limited under Article 82. But one of the issues we will look at is indeed what those minimum standards could be, what criteria should be set out by EU law, if any, for admissibility, and whether we should have special rules on forensic evidence in light specifically of the e-evidence package, which is being negotiated now. So this is what we will consider. As I said, nothing is decided yet. This is a long-term story. It's really difficult to harmonize procedural law at the EU level, and we have witnessed it in the past. We will see it again.
Okay. Thank you very much, Peter, for not only highlighting what the Commission has done and what the situation was and to which extent it has changed. I also see that as a call upon both academia and practitioners to convince the Commission that changes are needed. I think that is an excellent invitation to Jorge Espina Ramos to explain to the Commission what the problem is. Jorge, you have the floor.
Thank you very much, Andre. It's an honor to be with such distinguished speakers. So in my case, it is not true what Andre said. I'm last and least, but I will try to do my best to bring to you some reflections, not to bring clarity. Everything that I will talk about is based in practice. It's based in my work as a prosecutor since many years ago, specialized in international cooperation, and also based on my current work at Eurojust. But of course, it's always my personal opinion on every item that I might mention. Obviously, the admissibility in transnational, the admissibility of the evidence in transnational cases, it's a crucial thing to keep in mind. However, sometimes I have the impression that when dealing with cooperation mechanisms, we tend to forget sometimes that these mechanisms are a means to achieve an end. The end is to receive the evidence, but in order to be able to use it properly in trial, and therefore, eventually, if that is the case, to get a conviction. So every time I hear about the efficiency, I agree, we need cooperation mechanisms which are efficient, but we can't forget that this efficiency must come together with a purpose. There's a number of formalities, there's a number of procedural steps that need to be followed, and these also mean guarantees, so we cannot just forget about them. We cannot forget about them, obviously, when we're dealing with cooperation outside the European Union, but we cannot forget either when we're talking about intra-EU cooperation, which has become sometimes so easy based on the mutual recognition principles that we might be led to the mistake of thinking that no formalities are necessary, and that would be a mistake. Every time I read people from practitioners complaining about MLA procedure because it's very lengthy, because it's very cumbersome, I might agree, but the solution is not to come to different mechanisms which do not respect certain principles. The solution would be to improve those mechanisms so that they're not so lengthy, they're not so cumbersome, and they become more efficient. Because the real problem is that if we do not do so, we will find the actual problems later on. It is not about how flexible the authorities in charge of judicial cooperation are about doing things one way or the other way. It is about how it's going to be perceived and assessed later on by a different authority, which is the judge or the panel of judges who will be dealing with the case at trial. And sometimes this is something we tend to forget. And particularly in the digital world, as it has been mentioned, and is, let's say, the bigger context in which we are talking today, this can be very clearly seen. Let me bring to you two very short examples. First, the idea of setting up a secure channel to transmit EIOs, investigation orders, and MLA requests, like the electronic evidence digital exchange system, which is supposed to start very soon. This is a secure connection between the judicial authorities in Member State A and Member State B. That is correct, that respects the basic principles of the cooperation. But every now and then, and I've attended several meetings, preparatory meetings, you find that the technicians who participate in those meetings end up wishing that perhaps forensic lab in Member State A can directly connect to forensic lab in Member State B, decide among themselves what part of the evidence is relevant, which part is not, and then send only what they have agreed that it is relevant. That obviously would be absolutely wrong, because it misses the point of having judicial control throughout the process. And that is something that we, from the judicial area, need to be constantly reminded. This is one example of efficiency. I do not deny that might be more efficient, but clearly would not fulfill the parameters in which we need to move when talking about transmitting evidence from two member states. Or similarly, the Sirius platform, which was launched by Europol, and now Eurojust has also come on board, which is a platform for accessing through a voluntary cooperation digital data directly from internet service providers. That is correct. And this is the way in which we can solve a lot of problems and we can achieve the efficiency. But as long it is made clear, and that's the line that Eurojust has repeated over and over again, and it has been taken on board, that this is not and cannot become a substitution of the channels of communication of mutual legal assistance requests, particularly because in this case, since most of the service providers happen to be in the United States, we will be talking about extra EU judicial cooperation, which, as I said before, has some extra additional requisite because it is not based on the mutual trust that intra-EU cooperation is supposed to be based in. Therefore, admissibility of the evidence must, in my opinion, always be kept in mind. And it must be kept in mind as well that at the end of the day, this will be ruled, as it has been explained by Lorena, by the law of the state, by the domestic law, particularly by the law of the issuing state, because it is the issuing state, the one that will receive the evidence and will know what to do and which has an interest in getting somewhere. This means that cooperation mechanisms need to be respected. This means that the law of the issuing state must also be respected, even if we're talking about voluntary cooperation. The example that I mentioned about Sirius, not every member state has a legislation allowing them to accept the information sent through voluntary cooperation by the internet service providers. Well, that's something that those member states need to fix if they want to take the benefit and accept the benefits of having this platform or having this voluntary cooperation. And also, it is important to see how a certain type of innovative jurisprudence, an innovative case law is being developed, because sometimes the courts face themselves situations which couldn't possibly have been regulated by the law, because the actual problem is completely different, because the techniques have changed, the technology has changed, and end-to-end encryption was not foreseen when a certain member state regulated the way to access certain data. And it is interesting to see how some jurisdictions more than others seem to be more open-minded as regards accepting these new techniques. It must be ensured the integrity, the authenticity of the evidence. It must be ensured the preservation and the chain of custody. And sometimes it is not enough the mechanisms of the European Investigation Order, which have been mentioned, Article 9.2, I think, it is the one that has that little bit of forum regit actum principle. That is there to ensure the admissibility of the evidence. If I need a piece of evidence and I need to be taken in a particular way, I can ask the executing authority to do it in that particular way. However, in practice, we sometimes have faced the problems that the executing authority has said, no, I cannot do it because my law does not contain that formality. And that's not what the directive said or what the convention said before in Article 4. What it says is that unless it is clearly against the fundamental principles, you have to do it the way you are being asked to do it. One thing is that it is against your fundamental principles, and that could be acceptable, and normally it's already taken into account in the law. Let's think of a video conference with suspects. And a different thing is that you do not have that specific formality, but if you had it, it wouldn't be against your fundamental principles. In that case, it must be very, very clear that you have to do it. And it is not so clear. So this is why seeing things from practice, it might be good, as it has been mentioned before, to try to get a number of common standards at the EU level, which is the main area where all of us are moving, because it might help us solve those little problems. Obviously, with the caveat and with the basic principle of everything being always under judicial control. Being under judicial control simply means that the judicial authorities involved cannot be kept blind at any moment about the process that's being carried out. It doesn't mean that the judge or the prosecutor needs to know all the intricacies of the technology used or of the technical specificities of what is being done. Of course, that's why the judicial authorities, we have to rely on experts. But at the same time, we cannot rely, at such a level that we just leave them agree among themselves without having a proper control.
I think, Jorge, we must finalize. I think that the point is very clear from the needs from practice. I think we also, with a view to time and the questions that are put. Thank you very much for your contribution. I saw already the Commission nodding that it now understands the need for changes. I have a couple of questions on the screen. I think there's one practical question, whether the slides will be available. I think that is very easy to provide via the EDI Secretariat. There is a question specifically addressed, Jorge, to you. Is there a potential model platform or system of for the admissibility of digital data in the US that could be adapted for European Union jurisdiction? Or is the US system so different from ours? So is there something we can learn from the US when it comes to the admissibility of digital evidence? What is your view on that?
Well, the Sirius platform was the first reaction to deal with the exchange of evidence with the United States. The problem, as I said before, is that it reaches as far as it can reach, which is the voluntary cooperation. Because what we cannot do, unless we decide to change fundamentally the treaties which govern the international cooperation with the United States, unless we do that, we will have problems in carrying out these requests. So for the time being, we have that, which is based on voluntary cooperation. We also have the possibility, but I'm sure that perhaps Peter knows more about that, to negotiate about the executive arrangements based on the Cloud Act, but that's a different scenario. And the important thing, I think it would be much easier to try to solve this item internally, where we have more things in common at the level of the EU than to try to reach. It would be ideal, but I can imagine it would be much more difficult. And perhaps whatever solution we find internally at EU level might be a good example to expand, if the principles are respected and if it is possible, to relationship with other third countries like the US, which is of course crucial in the digital evidence field because of the reasons we are all aware of.
Okay, thank you very much. Peter, there is a question here for you. During the negotiation phase, was the internet industry, Google, Facebook, Apple, Microsoft involved? And did they show any willingness to contribute to the EU package on e-evidence, considering that they're playing and will play a key role in the dialogue with EU national authorities on the exchange of cross-border evidence?
The short answer is yes. The industry was consulted. Of course, the Commission consults every stakeholder, including industry, but not only. So their views were listened to and to the extent possible taken into account. But obviously the package is about establishing a structured way of obtaining data from industry in a way which is not yet foreseen in legislation. And at this stage, the views between the two legislators, Council and Parliament, are very different on how we should listen to industry.
Okay, thank you very much. Lorena, could you say something about the unterritorial nature of digital evidence? And do you consider that the rules on Forum Regis Actum apply, or is it completely unterritorial? Do you share that view, and how do you see it in relation to the EU data protection agenda? That is a question put to you.
Thank you. Thank you very much for these questions. Before I give my opinion regarding the non-location or unterritorial nature of digital evidence, I would say it's rather problematic when in the process of gathering. So you have to find where there is, but once it is not so much linked. It may be linked, but not so much to the admissibility, but rather to the jurisdiction, which is again very much linked to the admissibility of evidence, because the admissibility will depend at the end in which jurisdiction the case is going to be tried. But where the data are located is rather unimportant. Rather, I would say, who is in control of the data. To my mind, I know this is very much discussed, this is very much debated, but at the end, when we're talking about the cloud, the data absolutely scattered around the world, and it may be not important where they are exactly located, but who is in control of accessing to those data. So that would be my point, but obviously that needs to be further discussed in how to establish the connection between admissibility and jurisdiction. But I fully agree.
If I may intervene on that, we also just listened to Jorge Ramos, who reiterated it is the issuing member state when it comes to EIO that determines the conditions of the admissibility. And here on this point, you say it's the state that holds the data.
Not the state that holds the data who determines the admissibility at the end, but who decides where the data are located or whom you should address in order to get the data. So we don't mind where the data are located as long as Facebook or Google is in charge of giving access to that. And that will depend if Facebook and Google are located in the States. So the requested state should be the states, wherever the data are located. That was my point. Not on the admissibility. The admissibility of evidence, of course, at the end is the trial court who will decide according to their own national rules. And there is where we find that we need, I mean, the problem here is the same as in all procedural rules in criminal proceedings at the EU level. We are colliding with the reluctancy of the states to change their own rules, their own national legal order, because of course it's based on traditions and those traditions have to be respected. And on the other side, to achieve some kind of harmonization in order to make the transfer and admissibility of evidence easier, and not only dependent on comply with forum regis dactum abroad and then check again if lex loci has been complied with. So I fully agree with Peter Czonka that the scenario has changed, that the reluctancy of the member state should be overcome in the sense that we are dealing, when talking about electronic data, not so much where they're located, not so much of accessing those, not so much of transferring, because as long as there are secure channels, the transfer should be in place, but and common standards on the forensic labs. The forensic labs and the rules that apply in the mirroring, the storing, and again, the segregating of the data which are stored in computers or in other platforms. So I think forensic evidence standards are absolutely a necessity to make it transfer easily for both. For defense lawyers not to be suspicious of or unaware if the chain of custody has been respected or not, in all three stages that the forensic labs apply in electronic data, but also for the trial courts to be sure that they can rely on that expert evidence and those data, regardless whether they have been obtained, because they all stick to the same standards, forensic standards. And the three, of course, for the prosecution, because they will be much easier to prosecute the cases. Okay. So this would be my point. I know these are not very definitive answers, but just highlighting.
You will have a full project to run, and then you may come up with the final answers. Thank you very much. There's another question. I think maybe to all of you, will there be any minimum standards possible at the EU level to deal with artificial intelligence or machine learning empowered evidence in the context of criminal justice? Who would like to answer that one? It's not an easy one, but it's a question we're going to have anyway. Lorena.
Yeah, well, this was discussed already, not on common standards. I mean, the short answer to this very difficult question is, I don't know. I don't know if there will be common standards approved in machine learning, artificial intelligence issues. But I can confirm this was discussed with regard precisely to the automated cars, and at the level of the Council of Europe already also how to transfer that evidence, how to protect data at the cross-border setting, and focused on European Union Council of Europe level. There will be common standards. I don't know. There should be common standards. It will be very much needed. That is my point.
Okay. Lorena, you said, I don't know. I see Peter raising his hand. You know, Peter. Peter, you must unmute yourself and then you can speak.
Thank you, Andre. Technology is always a challenge if you don't know the system. We never use Zoom because we consider it unsafe. But what I can say is that we are discovering the issue. Clearly, this is something new, and it is coming up more and more as part of this issue of digitalization. And digitalization is now a priority for the Commission, partly because of COVID and its consequences for justice systems. And we realize that some of its aspects relate to how artificial intelligence works. And in police work, some evidence may be collected indeed through AI. So we are jumping on the bandwagon now. We will organize a meeting as well soon on AI and criminal law. I'm not sure we will harmonize ever admissibility of evidence related to AI, but perhaps in the minimum standards that we may develop on the basis of Article 82, paragraph 2, there should be something about AI related issues as well. This is one of the aspects that we will look into.
If I may add something very briefly. Indeed, I think this proves why this area is so convenient for EU action. Lorena mentioned before the need to respect the national traditions. I don't think we have a lot of national traditions as regard e-evidence. Certainly, Spain didn't have any in the first half of the 20th century or even in the second half, I'm not sure. So precisely because it's such a new area, and particularly if we talk about artificial intelligence, we have two options. Either we wait to see how many member states react and how each of them react, in which case we would have an absolutely fragmentary scenario, or we take the advantage that the treaty gives us to have a common approach, which can only come from action based on Article 82.2, and then try to go as far as we can. And in any case, I think it would be a better scenario than simply allowing 27 member states to develop freely. Ones will do it, others won't. So in the end, that's another, because it's such a new area, it's another additional reason why something, I believe, should be done at the EU level.
Okay, thank you very much. I have another question for you as a panel. We're not talking about admissibility of evidence, but can we do so without also dealing with the rules of how to collect evidence? And even stronger, can we talk about admissibility of evidence without discussing the evaluation of evidence? Because you may simply accept a rule saying this evidence that has been collected in another member state must be admitted, but it doesn't say anything to the panel and in the criminal proceedings of how to evaluate it. And can we simply focus on admissibility without what is there before and what comes after the evidence being admitted? I see that Jorge is the most insistent on taking the floor again. Jorge.
Thank you very much. I think this is a point which is absolutely relevant. Clearly, in my view, the admissibility needs to be connected with the rules to gather the evidence, because those rules will define the quality of the evidence gathered, and therefore will be the only guidance for the authorities in the issuing member state to see if it can or not be admitted. But a different thing, and I think that this distinction is very well done in the EPPO regulation. Lorena in his presentation mentioned Article 37.2. A different thing is the assessment of the admitted evidence. The admissibility of evidence is the previous step, allowing a piece of evidence to be put before the adjudicating panel or the adjudicating judge. But then it is so much more difficult, without affecting the independence of the judge who's going to assess, to put in written form rules to evaluate or to assess that evidence. In the end, you would have to end up drafting such wide and vague rules, which will literally mean nothing. We have a close example it's a different issue, but I think it's the same problem. In conflicts of jurisdiction, there was a framework decision which was criticized because it was too vague. It talked about many criteria. It didn't, in the end, it didn't give any practical guidance to the judge. The Spanish law took in all those all those criteria to be assessed, but in the end, since you cannot tell the judge which one you have to, how you have to prioritize them, because you don't know the details of the case. At the end of the day, the judge has 7 different criteria, which any of them could be used. And depending on the case, criteria number 1 would be better than number 4, or number 2 better than number 8. So in the end, you try to write down criteria to be followed, but simply you cannot do it because the adjudicating judge will be looking into the specific case. And I cannot foresee any law so detailed as to give guidance in that sense. Plus, it could be considered as affecting the independence of the adjudicating judge. So I would be a little more cautious there.
Okay, thank you very much. Very clear. Peter?
Yes, thank you. I fully agree with Jorge. The two must go hand in hand. Admissibility cannot be regulated without regulating some minimum criteria for the admissibility, which means regulating the procedure through which the evidence is collected. We have tried that in the EPPO regulation as well. As I said, for the most intrusive types of evidence, we had proposed that there be a judicial authorization, a minimum threshold of gravity for the offense, and the principle of proportionality. Whereby we mean that one cannot use intrusive evidence without trying the less intrusive ones, particularly for telephone taps and other IT-related evidence. That was thrown out by the member states, and this is exactly the same difficulty which we had in the past. Member states do not want to regulate the admissibility because they do not want to regulate the procedure through which we collect the evidence. They want to maintain the freedom that they have in conducting investigation, but also the freedom that the judge has in assessing, evaluating the evidence. So even if we manage to have common criteria for admissibility, we will not be able to restrict in any way the freedom of judges to value the evidence in a certain way. That will never happen. And this is why, indeed, the principle that Jorge mentioned in Article 37 of the EU EPPO regulation is important. Yes, it can be admitted, but in no way we will influence the judge to give it a certain value. That is an absolute constitutional freedom.
Thank you very much, Peter. So I would fully subscribe to what you say about the freedom for the judge to evaluate. If I refer to the jurisdiction I come from, the Netherlands, we have a very a liberal system when it comes to admission of evidence. But occasionally it may happen that we have on the table evidence that has been collected in an entirely different shape, and then whilst being admitted, is not used that much. The final word goes to Lorena. Could you briefly address the question on to what extent we need to have more rules on how to collect, and to what extent we need to harmonize evaluation?
Thank you, Andre. Thank you for the very interesting question, because we have been in and out discussing this already for more than 10 years, but it's still an issue and we don't come to a definite answer. I subscribe also what my colleagues have said already. And the issue, I mean, it's very clear that we're talking here on mutual admissibility as a way to foster the facilitating of cooperation, because there's no harmonization. Of course, there should be in parallel, to my mind, but I'm fully aware of what Peter is saying, that the member states really want to stick to their own legal order and not changing one single comma. And that might be okay. That might be okay, but more harmonization would really facilitate the admissibility, or not raise any questions for admissibility. Of course, how it is collected, it's so relevant to the admissibility. Of course, we're not talking on the pre-assessment, because the evaluation is out of question. It's an absolutely prerogative of the independent judge. Only I can think there could be introduced exclusionary rules. So do not assess this evidence, because it should in no way have no value. So violations of Article 3, and I think some others. But anyhow, with regard to electronic evidence, I think the point Jorge made, it was so interesting. The argument of we have to respect the national traditions and the principles and so forth does not apply here, because there's no traditions in place. And there's no specific regulation in many countries. And what I've been done within the Olaf study on the devices, forensics and electronic evidence, shows that all of them, there is no precise regulation in most, in the representative countries we have been studying, 10 countries, but they all stick to the same guidelines for Europol forensic labs. And just increasing that and stating this should be the rule to be followed by every member state would give a lot of security to the prosecutors, to the defendants, but also to the judges in deciding the admissibility. When we talk to admissibility, just 1 second, you told me very short, but I cannot. And just my last comment is admissibility. When we talk about admissibility, it's a different meaning in the common law countries and in continental countries. Just that. Thank you, Andre.
Okay, thank you so much, Lorena. Thank you very much, panelists. You were an excellent panel. Thank you, Lorena. Thank you, Jorge. Thank you, Peter. Thank you very much, participants, for listening to us, but also for your input in the questions, questions of high quality. And also thanks to the Secretariat of ELI for facilitating this webinar. With that, I conclude the webinar. I wish you well, and I hope that we can meet soon, once again, in an on-site ELI annual meeting. Bye-bye.
Bye.